So funny, but they don't stop running around at night. Are you in? Moved my Zoom call.
And it took 6 months for them to do the surgery. And then you'll free recovery.
This is the detention docket for August 14th. All right, so 10:30, let's go and start the detention docket. The purpose of this is to make determinations on children whether they should stay in custody or be released. Normally, this is held in the courtroom. However, due to restrictions on court proceedings because of the COVID-19 pandemic, the courtroom is closed to the public. We were doing this through Zoom as authorized by the Texas Supreme Court. However, in order to comply with Article 1, Section 13 of the Texas Constitution, also known as the Open Courts Act, we are broadcasting this on YouTube so the public has access to court proceedings. We can go ahead on this one. Just so everyone knows, it's going to be switching back and forth with me and Judge Porter. Go ahead and I'm going to start with the out of custody detention hearing. Jaden Tuis.
You'll have a seat here, and Dad, you'll have a seat in this chair. Are you on the screen too, Dad? If not, why don't you scoot over a little bit?
All right, hello, Mr. Tuis. I'm Judge Kim. This is a detention hearing. The purpose of this is for me to decide whether to take you into custody or to keep you in the community. If I take you into custody, the law says you have to see a judge every 10 days while you're here to review your case to decide to release you or to keep you here. You do have a right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you have the right to an attorney. If you or your family cannot afford an attorney, I'll provide one for you. All right, so Jaden, you are 16 years old. You're currently on probation.
Yes, sir.
And you're placed on probation in September of 18. I guess, Mr. Jones, how long is the probation for?
He's on probation until he's supposed to get off on the 19th of September, 2020.
Okay, so we're almost done with probation.
Correct.
All right, so July 29th, Arlington PD executes a search warrant after receiving a report from the National Center on Missing Exploited Children, and found out that some of the files uploaded to Dropbox were discovered to be illegal images registered to your address, your email address.
Yes, Your Honor, and I believe a computer and a cell phone was seized at the time as well, and a hard drive.
Okay, tell me, how else has he done on probation?
He successfully completed his sex offending counseling back on the 1st of June. He had been in there since September, I believe, of 2018, and he successfully completed June 1st, 2020.
Any other violations?
No, we did have, I believe there was a admin hearing that we had in the past, but other than that, he really hadn't had any violations since he's been on probation.
He hasn't had any, or really hasn't had any?
He hasn't had any violations since he's been on probation. I believe that admin hearing was because of a failed polygraph, I believe.
Okay. Okay, that email address that was reported is, do you know, can you confirm that's his email address?
They were able to confirm that that was his email address. They were also able to confirm that there were several other images of him in the account, and also some school information that had his name and everything listed on it in that same account. So they did a thorough investigation to find out that it was definitely him that was using that account.
Who's they? Is that Dropbox, or is that their own?
Arlington Police Department, I'm sorry. He has returned back to PSY since the information came through that he had been looking at the illegal images. He has returned back to PSY for individual sessions.
All right. So, Mr. Jones, here's the problem that I have, is that unfortunately this report is just full of conclusory statements. There's nothing here that in of itself would list statements that, if they were true, they're all conclusory, right? So we're not hitting any elements on this one. Yeah, based on this, I can't detain him. So there's, otherwise there's been no violations of probation. Is that correct?
Correct.
Okay. All right. So, Mr. Tuis, I'm going to let you know the law says I have to find that there's probable cause for you to have violated the law in order to detain you. I don't like what I'm reading here. It makes me inclined that I feel like I should keep you as a matter of safety, but I do have an oath to the law itself, right? And so that's not to say things don't progress or things don't change, all right? I may issue a warrant for you, or I may not. I mean, there may be nothing there. I'm not predicting anything. I'm just saying with what's presented in front of me right now, the law doesn't allow me to take you into custody, okay? So
Judge, he did admit to the image, to viewing the images himself as well. I don't know if that helps you or not.
well, so he admitted to viewing pornographic images?
He admitted to viewing the child porn, yes.
All right, and then that's a condition of his probation, correct?
Correct.
Okay, all right, well, Stephanie, better that back. Okay, so I needed, there has to be some kind of violation of probation then. Then Mr. Tuis, I don't know where things are going to progress. Mr. Hall is your appointed attorney on this case, all right? So at this point, then I am going to detain you for violating a condition of your probation while you're here. And the law says you have to see a judge every 10 days while you're here in order to review your case and decide whether to release you either to a facility or to keep you here until the case progresses. All right. Thank you, Mr. Tuis.
Okay, shall we go with me?
All right. So I'm going to pass this on to Judge Porter for the 10-day hearings. And I'll be back later with Maldonado. Thank you.
All right. Thank you, Judge Kim. Waiting on Emilio. Are you Emilio?
Yes, sir.
All right. The law says when you're brought into detention, you must see a judge with every 10 business days, or about 2 calendar weeks. So this is your 10-day detention hearing. My name is Judge Porter. This is just a detention hearing to determine if you should be released from custody or remain in detention. You have the right to remain silent and not say anything at all. If there's something you want to say, please do not shout it out. Instead, I want you to move your hand back and forth like this. That'll get my attention. That'll also get the attention of your attorney, Mr. Adler, and I'll create a private internet chat room for you and Mr. Adler to talk about what you want to say. That way he can advise you on whether or not you really should say it. Does that make sense?
Yes, sir.
All right. Anything you say at this hearing cannot be used against you at an adjudication or disposition or modification hearing, but it might be used against you at a future detention hearing. All right, you've been level 2-0 since the 12th. Mr. Jones, what brings Emilio to court today?
Emilio was brought in for safety plan violations, leaving the house unsupervised in the middle of the night while mom was asleep. I believe he left on 7/15/2020, around midnight or 12:30 a.m. and did not return home until 5 a.m. And mom stated that she believes he goes to his friend's house to get high. And he did test positive when he was brought in. He came in for marijuana, I'm sorry.
Hey.
Mom, what are your thoughts?
I mean, he's every day when I talk to him, I mean, he tells me he's trying his best every day, but some days are good and some days are bad. So, I mean, he has his days.
Well, and he had a bad day a couple of days ago because apparently he got real disruptive in the back, even after the staff tried to counsel him.
Mm-hmm.
Are you aware of that?
Yes, he told me that was Saturday or Sunday when that happened. I'm not sure.
That sounds about right.
Yes, he told me about it. He said he got really upset about something, but I mean, he didn't really go into details.
So he's still struggling to follow the rules in the back, it sounds like.
Yeah.
No.
Judge,
Yes, sir, Mr. Adler.
this is Ron Jones.
Oh, sorry.
We did get a psych eval done, and we got the results back. And I just FYI, it was recommended that he was recommended for a structured and comprehensive long-term secured residential drug treatment program. So I do plan to staff the case to see if there's any type of placement options.
All right, thank you, Mr. Jones. Mr. Adler, what are your thoughts?
Well, Judge, to expedite the case, maybe you can order a placement match instead of waiting for the resource staffing, so we can kill two birds with one stone.
Let's make it so.
And then we can make a decision at the adjudication dispo.
That sounds fair. Now,
thank you,
Emilio, that's not a guarantee that either myself or Judge Terry or Judge Kim will send you to placement, but we're going to have all of our ducks in a row ahead of time. That way, if that is the best solution to help you get better, then we've already have those pieces in place. But that's not a promise that that's actually going to happen, okay? All right. Anything else, Mr. Adler?
No,
All right. Emilio, for now, I'm going to order that you be detained. You got to get to level 10 for me, okay? I need you to prove to me that you can follow the rules in the back. Once you prove to me that you follow the rules in the back, then that'll give me a reason to believe, and give your mom a reason to believe that you can follow the rules at home. Because right now we don't have that evidence, do we? All right. Can you get there for me?
Yes, sir.
All right. Thank you, sir.
Your Honor, may I be excused, or do you still need me on?
I think that is your last case, isn't it?
Yes, sir.
Thank you, Mr. Jones.
All right, thank you.
Really, I don't even know.
All right, are you Mr. Burton?
Yes, sir.
Mr. Burton, my name is Judge Porter. This is a detention hearing to determine if you should remain in detention or be released to a parent or guardian. You have the right to remain silent and not say anything at all. If there's something you want to say, please don't shout it out. Instead, move your hand back and forth like this. That'll get my attention. That'll also get your attorney's attention, Ms. Bowers. I'll create a private internet chat room for you and Ms. Bowers to talk about what you want to say. That way she can advise you on whether or not you really should say it.
Yes.
If you give up your right to remain silent, anything you say at this hearing can be used at a future detention hearing, but at no other type of hearing. All right. Mr. Bowers, you have been level 10 since August 3rd, correct?
Yes, sir.
All right. Mr. Nava, what brings Mr. Burton to court today?
Your Honor, Benjamin was referred back on July 30th in custody by Hearst PD for assault bodily injury. According to the report, around 4 o'clock in the afternoon, officers were dispatched to a domestic where the victim is mom. She reported that Benjamin has not been taking his meds, and as well as that he's special needs and he was diagnosed with ODD. She raised her voice at him that day, and in response, he began throwing shoes at her. He also struck her with a phone charger, using it in a whipping manner, which caused a visible injury on her arm. Mom refused mediation, saying that this has been an ongoing issue with Benjamin, and then she told officers, Benjamin told officers that he did not remember the physical altercation. And Benjamin, since that day, when he got to level 10, he's maintained it. He's been taking his meds consistently, and he has been talking with mom daily over the phone. And mom told me that she has, over the phone, she feels that progress has been made over the phone, but she is present, as well as Benjamin's dad.
All right, Mom, what are your thoughts? Do you want Benjamin to come home?
Yeah, I mean, I think that I'm ready for him to come home. We have resources in place. Now, these are not any different resources than what we've done in the past. You know, we've done counseling, we've done behavior therapy and all of those things, but I'm, you know, prepared to get back involved. We did have a short period of time that we did not use those resources, and so those will be helpful. Also, accountability is necessary, so we'll definitely rely on you to help us to keep that accountability, especially through his court date. But now that he has shown that he can comply, obviously, and he can take his medication, that's what he's been doing. You know, this is what you said before, right, sir? Then, you know, detention may not be the right fit at this time.
Will an electronic monitor help you with compliance?
What would that do?
That's an ankle monitor to make sure that he's where
not,
he's.
Yeah, he's not a runner. I don't think it's necessary unless you do.
Okay. I'm gonna trust your judgment. All right, Benjamin. Let's see.
I think Ben's dad is here, and he had something to say about the ankle monitor.
Okay.
Yeah, I just was kind of curious as what your approach was. Is that specifically because you may think that he would run from the home, or is it a visual, I guess, stimulant to him for accountability? Is that, I just didn't know which direction.
It works differently for different kids. For some kids, it's needed because they do have a tendency to run away. For other kids, it provides exactly what you just said, a reminder that they're supposed to be obeying mom and dad's rules. And if they don't obey mom and dad's rules, then they get to come to a place where they obey Judge Kim's or Judge Porter's rules. It's a little less fun.
Correct. I understand that. I appreciate that. I don't know if we could potentially get Ben's input on that, if it's something that would help him from a visual standpoint.
Nope. Okay.
When it comes to those things, I defer to the parents, and he really doesn't get any input on that.
Understood.
Okay. Thank you, Judge Porter.
Ben does not get to make the rules here.
Yeah.
Sure.
Ben gets to follow the rules.
Understood.
Right?
Yeah.
Okay. So based on what mom and dad have said, I am not going to order the electronic monitor. Ben, I am going to order your release. However, it does come with conditions. You must follow all of your doctor's orders, including your medication management orders. Okay. So if mom wakes you up at 2:30 in the morning because the doctor has ordered you to take an aspirin, then, you know, even Judge Porter's a little grumpy if he gets woken up at 2:30 in the morning, but I got to do it if that's what the doctor wants me to do. And so you've got to do that too, okay? Because that's going to help you right now, okay? Will you make a promise to me and to your mom and to your dad that you will follow your doctor's orders, including all medication management orders?
Yes, sir.
All right. Mom, you got witnesses here. You can see the screen. You got a whole bunch of witnesses.
I do.
We're all going to hold him accountable.
Okay.
All right. That'll be the order of the court. Thank y'all.
All right. Thank you.
Thank you.
Yes.
Thank you, Ms. Bowers. All right, I am looking for Serena Byerly. There, oh, we had her. Are you Serena?
Yes, sir.
All right, Serena. My name is Judge Porter. I don't think we've met yet. This is a detention hearing to determine if you should remain in detention or be released to a parent or guardian. You have the right to remain silent and not say anything at all. If there's something you want to say, please do not shout it out. Instead, I want you to move your hand back and forth like this. That'll get my attention. It will also get the attention of Ms. Jacobson, your attorney. I'll create a private internet chat room for you and Ms. Jacobson to talk about what you want to say. That way she can advise you on whether or not you really should say it. Anything you say at this hearing cannot be used against you at an adjudication, disposition, or modification hearing, but it might be used against you at a future detention hearing. Does that make sense?
Yes, sir.
All right. Ms. Smiley, what brings Serena back to court?
Good morning, Your Honor. Serena was referred in custody on July the 1st of this year after the directive to apprehend that was issued due to her running away from her CPS residential placement, all church home, while they were on an outing.
All right, and she has history with the department?
She does, Your Honor. She is currently on probation for assault bodily injury. She has history beginning to November of 2017, which was supervisory caution. That was an assault causes bodily injury. Another in 2018, assault bodily injury, where she was placed on probation on January the 22nd of 2019. She has a referral in 2018 for injury to elderly, disabled, or a child, reckless bodily injury. Directed to apprehend. She has history on March 26th of 2019. That was a violation of court order, which was dismissed by the DA. She had a directive to apprehend April the 7th of 2019. May 7th, 2019, another violation of court order, which was extended, motion to modify, and it was extended, her probation. May the 10th of 2019, she had a directive to apprehend, which was supervisory caution by the department. December the 6th of 2019, she had another violation of court order, technical violation, and that was disposed of by the intake officer. And lastly, June the 16th of this year, which is the directive to apprehend that was issued by the courts due to the runaway.
Yeah. Now, in her favor, she has been level 1-0 since just a few days ago, correct?
She has maintained level 1. She just recently dropped to level 1 acceptable, but she has been on only level 1 since she's been detained.
Ms. Jacobson, what are your thoughts?
Your Honor, mostly we would request that Serena be released. I do have very serious concerns about the medical attention that she's receiving while she's in detention. I've been in contact with both her CPS worker and her probation officer in regards to Serena's wisdom teeth. It appears that her gums are bleeding. She has enough pain in her mouth where it's difficult for her to eat. When I was talking to her the other day, it was obvious that it was difficult for her to speak to me. And I have very serious concerns that this is medical neglect, and I need someone to intervene in this, because CPS is not allowing her to get the medical attention and detention is not getting her the medical attention. And so that's my primary concern today.
Ms. Smiley, Mr. Ainsley, did you hear what Ms. Jacobson just reported?
I did, Your Honor, and if I may, I have spoken with the medical director in the nursing clinic, and she has told me that this is not constituted as a medical emergency, and it can be taken care of in the near future. Also, due to the isolation, because they don't want the kids coming in and out to prevent a further spread of the virus, the girls are currently isolated. So they will only be allowed out if it is an emergency. I've let Ms. Jacobson know, in addition to Ms. Zarnecki, that I will be able to transport her. However, CPS would have to make that appointment for her. But due to the COVID-19 restrictions, if it's not an emergency, detention is not recommending that she leave. And it has been deemed that it is not considered an emergency. They have examined her mouth in detention, and that was what was reported to me.
Ms. Jacobson, does she have a dentist appointment?
She does not, Your Honor. Not now. She does not.
Ms. Jacobson, does she have a dentist appointment?
No, but my understanding is her mother is willing and able to set one up for her as soon as possible.
All right, well, but she's in CPS custody. CPS can make those arrangements. If she has a dentist appointment, then the court will authorize her transport to and from the dentist appointment. Serena, based on your history of running away and your lengthy history of referrals to the department, I thank you for being on level 1-0, but I cannot authorize your release at this time because I'm afraid you will abscond from the jurisdiction of the court. Ms. Jacobson, if a dentist appointment is made, then we will allow JPD to transport, in conjunction with CPS, transport Serena to and from the dentist, but back to detention.
There's another concern, Your Honor. From speaking with Julie O'Brien, the CPS supervisor, I believe it's my understanding, and Ms. Zarnicki can correct me if I'm wrong, but that the Medicaid that covers Serena while she's in CPS custody will not cover her while she's in detention. And so I believe that's the main problem why we're not getting a dentist appointment.
Well, as far as what I've got to determine whether or not she should be released from detention or not, the factors that I have to consider are whether she's likely to, the first factor among the statutory reasons I must consider is whether or not she is likely to abscond or be removed from the jurisdiction of the court. I make that affirmative finding today. And so based on that, I have to follow the law and determine that she must be detained. I will allow you to file whatever you need to see if you can facilitate additional medical care. Serena, put your hand down. But based on the statutory factors before me, I must order that she be detained.
Understood, Your Honor. Thank you.
All right, that will be the order of the court. Thank you all.
Thank you, Your Honor. May I be excused?
Yes, ma'am. Thank you.
Thank you, Your Honor.
Thank you, Ms. Smiley. Thank you, Serena. Okay, Mr. Lopez.
Damn it, you flipped them off.
Are you Mr. Lopez?
Yes, sir.
Mr. Lopez, we've met before. My name is Judge Porter. This is a detention hearing to determine if you should remain in detention or be released to a parent or guardian. You have the right to remain silent and not say anything at all. If there's something you want to say, please do not shout it out. Instead, move your hand back and forth like this. I'll create a private internet chat room for you and your attorney, Mr. Adler, to talk about what you want to say. That way he can advise you on whether or not you really should say it. Does that make sense?
Yes, sir.
All right. You're at level 3 unacceptable and have been since this morning. Reportedly, you've been a little bit of a potty mouth in the back. Mr. Reyes, what brings Mr. Lopez to court today?
Can you hear me? Good morning.
Yes, sir.
Sorry about that. Okay, so Mr. Lopez, he's been with us, Your Honor. He was brought in a warrant. I'm trying to go back into my other device.
Yeah, basically back on his first detention hearing was back on July 9th.
Yes, Your Honor.
In front of Judge Kim for failure to ID and evading arrest. He's had a couple of 10 days since then. I told him last time on the 31st that if he gets to level 1.0 and maintains it for 7 days, I'd consider his release.
Well, Your Honor,
backwards.
Well, he was doing fine for a few days up until he was into he ended up dropping his level to level 3 for, according to the staff, he was instigating a fight. And this can happen on the 9th of this month. So this is where we at. He has a pending motion hearing coming up on the 18th. That'll be on sometime on Tuesday and at 10:30. And also he has a resource staffing set for September the 9th at 10 a.m.
Mr. Adler, what are your thoughts?
Well, my first thought is that that's kind of backwards. I don't know how we can do an adjudication dispo without the resource staffing. Wonder if we can move up the resource staffing and then reset the case so we can do it all on the same day.
Mr. Reyes, doesn't that make sense to you?
Yes, Your Honor, absolutely.
Let's do that.
Okay.
All right, Mr. Adler.
Nothing further, Your Honor. Thank you.
All right. Xavier, Mr. Lopez.
Yes, sir.
What do you think I got to do?
I know you got to detain me.
How come?
I ain't keep my level 1 for 7 days.
No, man.
And
No,
I got
man.
no, that's why.
Not only did you not keep it up, you backslid way back. You're killing your attorney here. You realize that?
Yes, sir.
He's trying to do the best for you that he can. But if you're level 3 unacceptable in the back, you make his job 5 million times harder.
Yeah, I didn't even know I was gonna be a level 3. I had my 7 days, but I don't know.
What did you, if you start cursing at the staff, what do you think's gonna happen?
They're gonna take my points.
They're not gonna give you an extra scoop of ice cream, are they?
No.
All right, I got to order you detained. See you in a week or 2. Thank you, Mr. Adler.
Thank you, Judge.
All right, now I'm going to turn it back over to Judge Kim.
Thank you, Judge.
Judge Kim.
Still having hearings, so.
All right. Miranda Maldonado.
Good morning, Your Honor.
Morning. How are you?
I'm fine, sir.
One second here.
Your Honor, I'm taking this case of in lieu of Ronnie Mitchell, who is absent today.
That's fine. All right, Mr. Let's see, Miranda.
She's right here, Judge.
Okay, Ms. Maldonado, I'm Judge Kim. This is a detention hearing. The purpose of the hearing is to decide whether to keep you in custody or to release you. If I keep you in custody, the law says you have to see a judge every 10 days while you're here. You have the right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you have a right to an attorney. If you or your family cannot afford an attorney, I'll provide one for you. So Miranda, you're 14 years old. Everything started when you were, 11. So we brought you in for some kind of intervention prevention program. Then a couple months later, you were arrested for ag assault of a family member with a deadly weapon. The DA gave you deferred prosecution. 7 months later, you're brought in for theft of property, which our juvenile probation department decided to give you deferred prosecution. And then a year later, arrested for assault, family violence. Let's go on to, you're 13 years old now with a criminal mischief from $750 to $2,500. You got probation last October. While the case was pending, you picked up a graffiti charge, which the DA waived. So 2 weeks after you got probation, you're arrested for unauthorized use of a motor vehicle, which got added to your probation. And then we've had just little problems here and there. But let's see, 4th PD brought you in. So we issued a warrant for you on June 23rd for cutting off your electronic monitor and running away. You were arrested in Fort Worth Street. And you had evidently marijuana on you when you got into our facility. You tested positive for marijuana as well. All right, so Mr. Reyes, I know you're just covering for Mr. Mitchell, but why was she not charged with possession of a controlled substance inside a correctional facility?
That's something that I have to explore, Your Honor, because I was not aware of that.
All right. Yeah, I would ask JPD to explore that and see if it's appropriate or not for that offense.
Yes, Your Honor.
Right. So Miranda, just so you know, sneaking contraband drugs into a correctional facility is a felony level offense, all right? Even though if you're outside the facility, it's only a misdemeanor. All right, so Miranda, you're on probation for stealing a car, for criminal mischief, and you're smoking weed while you're on probation, you cut off your monitor and you run away. So at this point, I'm gonna go ahead and detain you, all right? You're not following up to your terms of probation. So, and especially since you're running away, it kind of tells me if I let you go, you're not gonna show up for court. All right. Yes, you have any questions?
About the cutting off my monitor thing, if I had
Hold on. I don't want you to talk about that, and the reason why, because your attorney's here, your attorney's gonna have to represent you and fight your case. And if you tell me too much now, you might make the job a lot harder for your attorney, Mr. Hall, Mr. Hall's, where's Mr. Hall? Usually,
I can talk to Mr. Hall.
yeah, Mr. Hall's. Oh, Anthony Green, I'm sorry. He's your man, red bow tie with the beard. He's like a handsome Willie Nelson. But that's your attorney.
For him today, I believe, Your Honor.
Yeah, Mr. Hall's your permanent attorney. Mr. Green is here just to make sure your rights are protected. And so he agrees with me right now. Is that fair to say, Mr. Green, for not to say anything about her monitor?
I definitely would advise her not to say anything about the situation.
Right. It just, you don't want to put yourself in a spot, Miranda. I'm just trying to protect your rights. Okay. I know sometimes as a judge, I'm considered as kind of like the enemy, but I'm not. I don't play on either team for the DA or for you. I just kind of keep things neutral. I just don't want you to hurt yourself and hurt your attorney's chances of helping you. Okay.
So I can't talk to my attorney?
Well, you can. Mr. Hall, Mr. Green, if you can relay the message to Mr. Hall that his client would like to talk to him.
I will text him as soon as we're out of court, Your Honor.
Okay, great. Thank you, Miranda.
Your Honor, may I be excused?
Yes, thank you, sir.
Have a nice weekend, Your Honor.
You too. Jose Moreno.
Bye-bye. Gracias.
So any kid that comes in, first 72 hours, they keep them kind of isolated. And so they have to wear that. And after 72 hours.
All right, Mr. Moreno, I'm Judge Kim. This is a detention hearing. The law says when a child is brought to a facility, you have to see a judge within 2 days, and I have to decide whether to keep you in custody or to release you. If I keep you in custody, the law says you have to see a judge every 10 days while you're here. You do have a right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you have a right to an attorney. If you or your family cannot afford an attorney, I will provide one for you. All right, Mr. Moreno, you turned 15 this month, and your history with this department starts when you were 12 with the possession of marijuana case, and then you turn 13 and you get arrested for evading arrest on foot. We let you out a month later, you get arrested for possession of marijuana at school or a drug-free zone, which you got probation for. Then while you're on probation, you get, see, we issued a warrant for you for some reason, but then, let's see, so 3 weeks after you get probation for possession of marijuana at drug-free zone, you again get arrested for possession of marijuana at drug-free zone. The DA dismissed that case. We let you out. 3 days later, you get arrested for criminal mischief from $750 to $2,500, which the DA also dismissed. Then you're, let's see, now at this point, you're 14 years old. You get arrested for theft of property from $30,000 to $150,000. You get released, and then you get arrested for, I guess, stealing a car, unauthorized use of a motor vehicle, which the DA waived, and evading arrest with a vehicle. So a car chase, which you got probation for on November of 2019. So now here we are. They bring you in, and you're on, he's currently on probation, correct, Ms. Lopez? Lopez, oh, you're on mute, ma'am.
There you go. He's on probation till November, Your Honor.
Okay, so you're almost done with probation, but it turns out you're now testing positive for weed while you're on probation for going to car chase from the police. All right. So now we had warrants for you from June 19th because you cut off your electronic monitor. Another one on July 29th because you were supposed to come to court. You didn't show up to court. And
excuse me, there is a message for you.
when you're arrested, the police found marijuana on you. They said a good amount. Do we have any idea, Ms. Lopez, what a good amount is these days?
No, Your Honor, this is, he was with Miranda, so we're gonna have to look into why nothing was done about that. They were together, Your Honor.
Oh, the previous girl?
Yes, sir.
Oh. Both cut off their EMs. Oh, and you know, Jose, you're not supposed to associate with other kids that are on probation while you're on probation. Hey, Ms. Lopez, what did he do right on probation?
I'm sorry, Your Honor?
What did he do correctly on probation?
Well, Your Honor, actually, he was in detention pending. We've done all the legwork for placement, and Judge Porter let him out on EM as maybe a home before placement.
Yeah.
and he cut off his monitor.
Yeah, so we tried to reward him for behaving here.
Right.
Because
He did-
all right, so
he
tell me
did
about
have
this
one.
aggravated robbery from March 25th.
That's the one that's pending, Your Honor. He has been set for September 14th.
Tell me the facts of it. I have nothing here in the report.
Basically, they robbed an ice cream person, Your Honor, at gunpoint and took his money and his cell phone.
Oh, is that the one up here in Northside?
Yes, sir.
Okay, one of like the neighbors.
One of them, yes.
Yeah, saw them.
That's the one he's being charged with having a weapon and having the stuff on him.
Okay. Yeah, so it's like one of those push, like
Push
Mexican.
carts, yes, Your Honor. Walking. They pulled over in a vehicle and robbed him.
I know, ice cream carts just bring happiness to everyone. And to rob, yeah, that's, all right. And Jose was the one with the gun?
And that's it. That's, I believe is what it says, Your Honor. Allegedly, he had the gun.
All right, so Jose, you know my stance on, I really don't like it when kids have guns. So it's kind of a gift when we let you out when your case is pending. But evidently you earned it if you were released on the electronic monitor. And then while you're out, you cut off your monitor, you're smoking weed, associating with other people on probation. And when it's time for court, you don't show up for court. So I see absolutely no reason why I need to release you. I don't think you're a peer for court. I think you're a danger to others. I think you're a danger to yourself. All right? Thank you, sir.
Thank you, Your Honor.
Thank you.
Excuse,
Who said may I be excused?
Brian Newman.
All right. Sorry, Mr. Newman, there's not a whole lot you could have argued on that one.
Oh, I understand. I was asking if I could be excused.
Have a great weekend.
Thank you.
All right. Waiting on Mr. Parker.
Good morning.
How are you, Mr. Parker?
Oh, good, sir. How are you?
Okay. Let's see. Is Mr. Houston here?
Parker is mine, Your Honor. Mr. Crawl,
Yes, I was actually looking for Dwayne Houston.
sorry.
That's okay. Mr. Green, do you mind helping out with Mr. Houston's case on Danny Parker?
Not a problem, Your Honor.
Thank you. All right, Mr. Parker. My name's Judge Porter. This is a detention hearing to determine if you should remain in detention or be released to a parent or guardian. The law says when you're brought into detention, you have to see a judge every 10 business days. You have the right to remain silent and not say anything at all. If there's something you want to say, please don't shout it out. Move your hand back and forth like this. I'll create a private internet chat room for you and your attorney to talk about what you want to say. That way he can advise you. Really, he'll advise you to keep quiet today because there's nothing you can say that will help you today. All right, Mr. Parker, you are level 1-0 and have been since August 3rd. Mr. Crawl, how's he doing in the back? How's everything else going with him?
He doesn't have one right up, Your Honor, the whole time. Mother's currently here. Mother has relocated to Abilene, Texas, which is why she was not here at the first initial hearing. She has come in, provided all the information needed for me, and his court case is set on August the 28th.
Mom, do you want Mr. Parker to come home today?
Yes, sir.
All right, if I release him to you, can you make sure he gets back to court when he's supposed to?
Yes, sir.
All right. Mr. Crawl, given that they're all the way in Abilene, is this a case where we need to have an electronic monitor?
I do not believe so. Mom moved out there with her sister and the grandmother. And between the three, she has said that they can watch him 24/7. I believe this is a case where if there is permanent residency, we'll be asking for a transfer disposition.
All right. Okay. I had originally thought about some different conditions of release, but I'm going to go ahead and waive those. All right, Mr. Parker, you got to level 1-0. You maintained it. You kept up your end of the deal. I'm going to keep up my end of the deal. Here's the thing, though. I need you and I expect you to maintain level 1-0 at home. All right? That means if mom assigns you some chores, you have to do those, right?
May I ask you a question?
Go ahead.
Is there any way I could get drug classes?
Get what?
Drug classes.
I want you to talk to your attorney about that, because if that is something you are genuinely interested in, then your attorney as well as Mr. Kroll, they can all work for that for you, okay? And that would make me very happy. Because when you came in, you tested positive for meth, and meth is a really, really scary drug, especially for someone your age, whose brain is still forming and congealing. Meth can really fry your brain at your age. So you got to stay away from that, all right? Mom, you need anything else from me?
No, sir, thank you.
All right, I'm going to authorize this release. Thank you, Mom. I appreciate your help.
Yes, sir, thank you.
Right. I believe Judge Kim will be back for Zapata.
Thank you, Judge Porter. All right, Brandon Zapata. All right, Mr. Zapata, I'm Judge Kim.
Hello.
The detention hearing. The purpose of this hearing is to make a decision whether to keep you in custody or to release you. If I keep you in custody, the law says you have to see a judge every 10 days. You have the right to remain silent, and you have the right to an attorney. If you cannot afford an attorney, we'll provide one for you. All right, so Brandon, you're 17 years old. All right. So this all started when you were 16 with a unauthorized use of a motor vehicle and a runaway. Then you were let out a month later, a burglary of a vehicle. And then I guess you were let out, another runaway and a burglary of a vehicle. So I guess you're on probation for burglary of a vehicle. Mr. Miller, when does this probation expire?
His probation expires on his birthday, 12/12/2020, when he's 18.
Okay. All right. So, Brandon, you were assigned to the probation officer's caseload. You see, missed out on phone calls and texts. You had 3 virtual visits, and you missed those. Mom says you're not following the rules of the home, and you're out of control. Since you think you'll be 18 years old in 4 months, you think you can do whatever you want. She says you steal her phone. She called the police recently, and that you come and go when you want. When she told you about the virtual visit for last week, you told her that you'll be home Friday afternoon and the PO could visit with him then. And when we asked your mom where you were, she said she didn't know. All right. So on August 7th, Trinity Springs called us, said that you were brought in by the police for making threats to shoot mom and kill yourself, that they held you for mental health evaluation. They said you were being discharged, so the sheriff brought you over here for violating your probation, and you're testing positive for weed. Well, tell you what, Brandon, here's the deal. If you think that our probation officer has to visit you on your schedule, you're wrong. All right. So at this point, I'm going to detain you. So that way, if the probation officer needs to see you, he knows exactly where you are, and he can visit you on his schedule. Also, I want to let you know you are 17 years old. All right. So let me explain the way this works. In Texas, if you are under 17, you have to be held at the juvenile detention facility. If you're 17 or older, you can be held. If you're 17, you can either be held here at Kimbo or downtown. If you're 18, you have to be held downtown. So at this point, I have the discretion of holding you either place. I'm inclined to keep you here because I expect our 17-year-olds to be a good example for our kids here that are younger than 17. But I'm going to let you know that if your behavior level is anything but a 1, then I'm going to go ahead and have you housed downtown until your case is resolved. Okay. Unless you just tell me up front that you don't want to be here and you'd rather be downtown, we'll just accommodate you then. All right. So, your day. I'm sorry?
What's happening? The last part you said?
Oh, if you tell me that you'd just rather be downtown, then I'll just keep you downtown. So I won't waste my time keeping you here at Kimbo. Okay?
Yeah, I'd rather be downtown.
You sure?
Yeah.
Hey, you know, the food's worse, the beds are worse, the accommodations, the people you're with, that's all worse. You get that, right?
Yeah, I understand that.
Okay, well, I'm not gonna waste my time here. So I'll go ahead and order the sheriff to take you downtown. You'll still have your 10-day hearings while you're here. We'll just do it remotely through Zoom from the county jail. Okay?
All right. Yes, sir.
All right, so I'm gonna go ahead and detain him, and I'll get an order to the sheriff if we can go ahead and transport him downtown today. All right, thank you, Mr. Zapata. Okay.
All right. Detention, please do not bring in the next child. All right. These hearings have been broadcast live on YouTube in compliance with the open courts provision of the Texas Constitution. However, the law says when a child is under the age of 14, the hearings should be closed to the public unless the interest of the public in hearing the proceeding involving an under 14 age child outweigh the privacy interests of the child. There having been no such showing made to the court at this time, the court will close the hearing to the public, ask everyone who is on this Zoom meeting who is not directly involved with any remaining case or cases to voluntarily remove themselves from the Zoom meeting, and the court will stop the live stream on YouTube. Judge Kim, if you will, let's see, go ahead and never mind. Judge Kim, if I could ask you to stop the live stream on YouTube.